A Supreme Court fight is now aimed at one of the most confusing carry rules in America. And if you carry legally, this case could decide whether walking into a normal store turns you into a criminal overnight. Quick question before we continue. Are you subscribed? Because this channel exists for one reason: to help regular gun owners keep up with fast-moving legal changes before those changes wreck their lives. If you care about your rights, your permit, and your freedom, hit that subscribe button right now. Here's what just happened. The case is called Wolford v. Lopez, and the Supreme Court agreed to hear it after a lower court let Hawaii enforce a rule that flips normal carry expectations upside down. In simple terms, Hawaii says that even if you already have a concealed carry permit, you still cannot bring your handgun onto private property that is open to the public. This includes places like a store or restaurant, unless the owner clearly says yes, not maybe, not probably, not there's no sign, so I should be fine. The state wants express permission first. Now, this is where it gets interesting. Most people think carry laws are mainly about permits, background checks, and so-called sensitive places like schools or courthouses. But this case is about something more basic. It asks who gets to set the default rule when you walk into a public-facing business. Is the rule carry is allowed unless the owner says no? Or is the rule carry is banned unless the owner says yes? That sounds like a tiny difference. It is not. It changes everything. After the Supreme Court's Bruen decision knocked out New York's old special need carry system, several states rewrote their laws. Hawaii did. California did too. And they did not just create lists of banned places. They also changed the default on private property open to the public. Hawaii's law says a permit holder generally needs clear permission from the owner before carrying there. California went even further, using a sign-based system that is even stricter. So if you are thinking this is just a Hawaii story, it is not. Hawaii is the case in front of the court, but the outcome could matter far beyond Hawaii. Here's the part nobody's talking about. This is not just about whether a gun is allowed in one restaurant or one shop. This is about whether the government can make lawful carry almost useless by creating a maze of rules that ordinary people cannot realistically follow. The petitioners in the case argue that this kind of rule makes it practically impossible to carry for self-defense during normal daily life. Think about your routine. You leave your house, you stop at a gas station, you pick up coffee, you run into a grocery store, you grab lunch. If the law says each one of those places is off limits unless the owner has given express permission, then your permit starts to look more like a trap than a right. And that is why this case matters so much. The Supreme Court did not take every issue from the Hawaii and California lawsuits. It took a narrower question. The justices are focused on whether Hawaii can presumptively ban licensed permit holders from carrying on private property open to the public unless the owner affirmatively gives express permission. That is the heart of the case. Not every carry restriction. Not every sensitive place. This one key default rule. Let me break this down for you with a real-world style example. Imagine you have a valid permit. You drive to a shopping center. There is no metal detector, no armed guard, no guns welcome sign, no guns sign. Under the kind of rule Hawaii is defending, you may be expected to assume you cannot legally carry there unless the owner has clearly said yes. Now ask yourself this: how are you supposed to know? Are you supposed to walk into every business and ask, "Excuse me, do I have express authorization to exercise a constitutional right while buying toothpaste?" That is the confusion at the center of this case. But wait, there's something even more important. The penalties are not imaginary. This is not one of those online arguments where people say, well, technically, maybe. A violation under Hawaii's law can be charged as a misdemeanor with up to a year in prison. So when people shrug and say, just play it safe, what they really mean is give up carrying almost everywhere you actually go. That is why the challengers say the law does by indirection what Bruen said states cannot do directly. If you're finding this helpful, imagine what you'll learn in my next video about the exact words that can keep a simple gun encounter from getting worse. Subscribe now so you don't miss it, because staying informed before a ruling drops is always better than learning the hard way after. Now let me explain why the legal fight got so serious so fast. Lower courts looked at these new post-Bruen laws and split on how far states can go. In the Hawaii and California cases, district judges blocked some parts of the new rules. Then the Ninth Circuit stepped in. It allowed many restrictions to stay in place, but not all of them. That matters because this was not a full win for either side. The appeals court said some bans could not stand, but it still let Hawaii keep that private property default rule. That is the piece the Supreme Court decided to review. Most people get this wrong. They hear private property and think the case is about forcing business owners to allow guns. That is not really the question. Property owners can still decide what they want on their own land. If a restaurant owner says no guns, that is a no. If a store posts a valid restriction, you need to follow it. The fight is over whether the state can step in and automatically make all those places gun-free first, unless the owner jumps through the state's chosen method of saying yes. That difference matters, because default rules shape behavior. Here's a hypothetical example to explain this. Let's say two coffee shops sit across the street from each other. Shop A does not care if licensed customers carry. Shop B does not want firearms inside. Under the older common sense approach, Shop B would post a sign or tell people no. Easy, clear. The owner who wants a ban says so. But under Hawaii's approach, both shops start out as no-carry zones, unless the owner takes affirmative steps to allow licensed carry. In other words, the state makes the choice for both owners on day one, and that creates two problems at once. First, it burdens the permit holder, who now has to guess where carry is allowed. Second, it changes the rights of the property owner because the state is speaking for that owner before the owner speaks for himself. That is why even some people who are not hardcore gun rights activists are watching this case closely. It is not just about firearms. It is about who decides the default in everyday public life. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Here's the part that shocked me. The challengers told the court that this kind of rule wiped out lawful carry on an enormous share of publicly accessible land in Maui County. Their argument is simple. If most businesses are private property open to the public, and if most owners do not post explicit permission, then a permit holder loses practical access to most places he actually goes. That is why they say the law effectively nullifies the right to bear arms in daily life. Have you ever wondered why these cases feel so confusing? It is because the fight is no longer just over whether you can get a permit. In many places, the new battle is over where that permit means anything. A right on paper is one thing. A right you can actually use while living your normal life is something else. And that is exactly what the justices are being asked to sort out. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the people who stay ahead of these legal changes instead of reacting to them too late. Hit subscribe right now so you never miss a major carry update. Now let's get to the biggest twist in this whole story. The U.S. Department of Justice backed the challengers. Yes, the DOJ filed a brief supporting the gun owners in this case. In plain English, that is a friend of the court filing saying, "We think the lower court got this wrong." The DOJ argued that Hawaii's rule is blatantly unconstitutional as applied to private property open to the public. It said, states cannot get around Bruen by using indirect tricks that turn public carry into a dead letter. That is a very big deal. And when the federal government jumps in on the side of the challengers in a Second Amendment case, people notice. And the DOJ did not just talk about Hawaii. It also pointed out that other states passed materially similar restrictions after Bruen, this including California, Maryland, New Jersey, and New York. So again, if you think this is some isolated island issue, think bigger. A ruling against Hawaii could send a message to several states that tried a similar playbook. But here's the crazy part. Hawaii was not alone on its side either. The state argued there is no automatic right to bring a gun onto someone else's property without consent. And to be fair, that argument sounds strong at first. A lot of viewers will hear that and say it makes sense, but the challengers answered with a simple point. The issue is not whether owners may ban guns. Of course they may. The issue is whether the government can rewrite the default rule so broadly that a carry permit becomes useless in ordinary public life. Now, this is where oral argument got very interesting. Reports from the courtroom said several justices sounded skeptical of Hawaii's position. Chief Justice Roberts suggested the Second Amendment has too often been treated like a disfavored right. Justice Alito said Hawaii was pushing the Second Amendment into second-class status. Justice Gorsuch questioned whether the state's historical support was really strong enough, and Justice Kavanaugh appeared to signal that if the text covers the conduct and the history is weak, that should be the end of the case. That does not mean gun owners have already won. Let me say that clearly so nobody clips this out of context. The Supreme Court has not issued its final decision yet. The case was argued, but the final opinion is still pending. So do not make the mistake of hearing excitement online and assuming current law has already changed. It has not yet. There was also another important sign of support. Earlier in the fight, a group of states filed an amicus brief backing the challengers. They argued that Hawaii's restrictions were too sweeping and not supported by our historical tradition. That matters because it shows this is not just one lawsuit driven by one set of plaintiffs. There is broader government support for the idea that states cannot bury public carry under layer after layer of practical obstacles. So what should you take from all this right now? First, do not assume your permit lets you carry anywhere private property is open to the public. Check your current state law and the law of any state you travel to. Second, do not assume that because a business has no sign, carry is automatically lawful. In some states, that assumption could be deadly to your legal case. Third, Do not assume a future. Supreme Court ruling will erase every restriction. Even if the challengers win, private owners will still have rights, and some sensitive place rules will remain in place. This is also the moment to think carefully about how you explain this issue to friends and family. The cleanest way to say it is this. The case is about defaults. It is about whether the state can make no carry, the automatic rule let businesses open to the public unless the owner gives express permission. That is why the case matters. It is about defaults, daily life, and the difference between a right you technically have and a right you can actually use. Laws change fast. Court rulings can hit with zero warning. Subscribe now, because the next video will break down exactly what a Supreme Court ruling means. So here's the bottom line. Wolford v. Lopez could become one of the most important carry cases since Bruen because it targets a rule that turns life into a minefield. The DOJ backed the challengers, multiple states backed the challenge, and several justices sounded skeptical, but the final ruling is still pending. If you want straight, simple updates without the legal word salad, subscribe right now and stay with this channel. I would rather help you understand a rule today than watch you find out about it after a stop, a charge, or a courtroom fight tomorrow. And one final reminder, this video is for education only, not personal legal advice. If your freedom is on the line, talk to a qualified attorney in your state.